All right, so we continue on with our discussion surrounding freedom of expression and unprotected and less protected speech. So far we have discussed several categories under unprotected and less protected speech. We've talked about incitement of illegal activity, speech that provokes. We've also talked about sexually oriented speech, which contains in that category obscenity, profanity, explicit but not obscene speech, or speech that we've come to call protected but low value speech, right? On this video, we want to introduce and discuss the concept, or a couple concepts. First, the concept of commercial speech, and then end the video with discussing tort liability for speech. So, as we venture into the topic of commercial speech, there are several important points regarding commercial speech that we want to keep in mind. First, we want to consider the question of whether commercial speech should be protected under the First Amendment at all, right? And we'll talk about cases where the court has considered that question and answered that question over time. Second, what is commercial speech, right? Once the determination is made that it should be protected under the First Amendment, then how do we define, or how should commercial speech then be defined? And then finally, what is the applicable test for when government may regulate commercial speech? So we start our discussion on commercial speech with these three questions in mind. And so it's important to understand and to appreciate that initially the Supreme Court held that commercial advertising was unprotected by the First Amendment, right? And so in 1942, the court held in the case of Valentine versus Christensen that commercial speech was not protected under the First Amendment. Commercial speech remained unprotected under the First Amendment until the case of Bigelow versus Virginia, which was a 1975 case that the court considered there and declared unconstitutional a state law that made it a crime to encourage or prompt the provision of abortion services. Specifically in Bigelow, the court held that advertisements for abortion services in newspapers were protected under the First Amendment. So you have this span between Valentine and Bigelow of a little over 30 years or so, right? From where commercial speech goes from being completely unprotected by the First Amendment when the court initially considers the topic to then being determined to be protected. In Bigelow, specifically, the court held that advertisements for abortion services in newspapers were protected by the First Amendment. The court said that speech is not stripped of First Amendment protection merely because it appears as a commercial advertisement. And so over this 30-year span, you see the court shift this position regarding commercial speech from being one or a type of speech that's not protected to a type of speech being protected or considered protected under the First Amendment. A year after Bigelow, the court takes up the question again, and it made it even clear that commercial speech is protected by the First Amendment and that Valentine was no longer good law. And the court solidified this position, if you will, in the case of Virginia State Board of Pharmacy versus the Virginia Citizens Consumer Council. In that case, under a Virginia law, a pharmacist was considered to be engaged in unprofessional conduct if he published, advertised, or promoted in any manner whatsoever a price or fee or any sort of premium or discount terms for any drugs which could be dispensed only by prescriptions, right? And so the issue that the court considered in this particular case was whether commercial speech has First Amendment protection such that a state may not ban certain commercial speech, i.e., advertising of prescription drugs. The court held that commercial speech is protected under the First Amendment such that a state may not completely suppress the dissemination of conceitedly truthful information about entirely lawful activity. However, this speech may be regulated by a state to ensure that the ads are not false, deceptive, or misleading, and do not advertise illegal transactions. So you see from the court's language that they were very deliberate in articulating that this type of speech should be protected by the First Amendment, so long as it was truthful, right? That it was not untruthful or false, and so long that as it was legal. If it were untruthful or false or deceptive or misleading, or if it were illegal, then it could be regulated and would not be protected by the First Amendment. And so with this holding, the court was really foreshadowing of how commercial speech would come to be interpreted in the future, right? The court said that commercial speech was expression that proposes a commercial transaction. And so, again, a little bit of foreshadowing of how it would come to even define the term commercial speech. The court noted that having an economic interest should no more devalue speech for pharmacists any more than for labor union members in an employment type of dispute, right? The court noted that advertisements may touch on matters of public interest, and price information about prescription drugs was of more than an economic concern for certain individuals. Obviously, the people who needed it, right? If they were sick or elderly. Price was also a concern for individuals if they were poor, right? And so all of this information was determined by the court to be important. So we have this foundation, if you will, this determination by the court that commercial speech should be protected under the First Amendment. So once the court decided that commercial speech is protected by the First Amendment, the issue inevitably arose as to what is commercial speech, right? How do we define it? How do we know it when we see it, right? While some of it is obvious, right? When you talk about the price of merchandise for sale, like in the Virginia Board of Pharmacy case, others are not so obvious, right? And the Supreme Court, interestingly enough, has never defined commercial speech. However, the 1983 case of Bolger versus Young Drug Products directly addressed the question of what is commercial speech, right? In that case, Bolger involved pamphlets that had been distributed by a condom manufacturer, and these pamphlets discussed condoms generally, but also discussed other products that had been manufactured by the company. In arriving at an opinion or rendering an opinion, the court had first to determine what kind of speech the pamphlets were before determining what degree of protection the speech had under the Constitution. The court noted that a mailing may have mixed components that has both commercial and non-commercial speech aspects. And so the court determined a combination of certain characteristics justified the pamphlets be characterized of commercial speech. And collectively, these characteristics is what made the speech commercial in this instance. Those characteristics were, one, that there was an advertisement, right, of some form. And so these pamphlets were, in fact, an advertisement. Another characteristic was that they made reference to a specific product. And then the final characteristic was that the speaker, in this case, the advertiser, right, or Young Drugs Products, if you will, had an economic motivation for the speech, right? And so a combination of these things, not these characteristics, not taken individually, but taken together, combined, if you will, to define what commercial speech was. A few years prior to Boger, however, in the Central Hudson case, the court said that commercial speech was an expression related solely to the economic interests of the speaker and its audience, right? And so that kind of talks a little bit about that third piece of how Boger came to define commercial speech, and that is that the advertiser has an economic motivation for the speech. And so this is the closest in Boger that the court has ever come to defining commercial speech. Remember, they have never formally or officially defined commercial speech, but in Boger, they considered these three characteristics in totality or together to really kind of serve as how one would go about defining commercial speech. Now, it's interesting rather to understand that beginning, we talked a little bit about the Central Hudson test. And so beginning with Central Hudson Gas versus the Public Service Commission of New York, the court formulated and refined a test for when the government can regulate commercial speech. And this test, as we'll talk about it here in a second, it is essentially a form of intermediate scrutiny. And so in the Central Hudson case, we see the court again establishes a test for when the government may regulate commercial speech. And so in Central Hudson, the state of New York prohibited the electric company from advertising because it wanted to discourage energy consumption. And it felt that the company had a monopoly and really didn't need to advertise, right? And so in Central Hudson, the court considered the question of whether this Public Service Commission regulation violated the First and 14th amendments, because it completely banned promotional advertising by the electric utility. And the court held that this commission order restricts only commercial speech. That is, expression solely related to the economic interests of the speaker and its audience. The court noted that the First Amendment, as applied to the states through the 14th Amendment, protects commercial speech from unwarranted regulation. And in arriving at its conclusion or at its holding, the court articulated a test that it used to determine whether the commercial speech gets First Amendment protection. The court asked 4 questions in that regard. First, does the speech advertise illegal activities or constitute false or deceptive advertising that is unprotected by the First Amendment? Remember, we talked a little bit about the fact that the court frowns upon false advertisement or deceptive advertisement or advertisement that advertises illegal transactions. The court was very clear about those things in the Virginia Board of Pharmacy case. The second question that the court asked is the government's restriction justified by a substantial government interest? Sounds a little bit like intermediate scrutiny, right? Is the government's restriction justified by a substantial government interest? Third, does the law directly advance the government's interest, right? And so when you take 2 and 3, you really are or should be comfortable now to know, yeah, that definitely sounds like intermediate scrutiny. If the answers to both the second and the third prong are yes, then the court asks, is the regulation of speech no more extensive than necessary to achieve the government's interest? Now, in applying this test in this particular case, the court determined that the ads were truthful and concerned lawful activity, right? So the first prong of the test was met. However, despite the fact, the court also determined that the government interest was substantial, right? However, despite the fact that the government interest was substantial, the court noted that the regulation was more extensive than was necessary to further the state's articulated interest in energy conservation. The court specifically noted that a more limited restriction on the content of promotional ads might better serve the state's interests. So, again, looking at the test as a whole, the court held in Central Hudson that the particular Public Service Commission order in this case did not meet constitutional muster under the test that it articulated in this particular case. Note again, for emphasis, that just as the court noted in the earlier case of the Virginia Board of Pharmacy versus the state of Virginia, that advertising for illegal activity was not protected, right? Also, advertising that is false and deceptive is not protected, right? So as the court underscored those particular issues, just like it had discussed in the Virginia State Board of Pharmacy case. It's important to also know that while some advertising may be true and it still may present problems. Think about, for example, ads that seek to promise certain results in solicitations, if you will, of prospective clients, right? These types of ads may be regulated by the government to combat potential deception and or for consumer protection. So be sure to keep that in mind. Now, so we have our test, right, of how the government should go about regulating, or the standards, if you will, that the government must meet in regulating commercial speech. There's one important area, however, that is implicated when you consider the last three prongs of the Central Hudson test. That's essentially number 2 and 3 that we can call, or that sounds very much like intermediate scrutiny. And that fourth prong of, is the regulation no more extensive than necessary to achieve the government's interest? And that area is, or those areas rather, come up in the regulation of ads to discourage certain types of behavior, namely alcohol sales and tobacco advertising, right? And we see that implicated in a couple of cases in our reading. The first was the 44 Liquor Mart versus Rhode Island case, right? In that case, the Supreme Court declared a state law that prohibited price advertising of alcoholic beverages unconstitutional. The court noted that the government cannot prohibit price advertising of alcohol, even though the government has an important interest in encouraging temperance, right? Remember, the government always has the ability to regulate, or let me backtrack that. The government always has the obligation to keep in mind the health, safety, and welfare of its people, right? And so the court notes in the Liquor Mart case that the government can't prohibit price advertisement of alcohol, even though it has an important interest in encouraging temperance, right? And this is especially true when the government, in this case, has offered no evidence to support the conclusion that this prohibition would significantly advance the state's interest in promoting temperance, right? Furthermore, the court noted that there are less restrictive ways that the government could have selected in order to advance its objective, right? And so we see the court frown upon this regulation in 44 Liquor Mart and ultimately declares this prohibition on price advertising of alcoholic beverages unconstitutional. Subsequently, the court considered a similar issue in advertising of tobacco sales in the Lorillard versus Riley case. Lower Lard was decided in 2001 and considered a Massachusetts law regulating tobacco advertisement, right? And this particular law prevented advertising of tobacco products within 1,000 feet of a school or playground. And it also required places that sold tobacco products to place ads for these particular items at least 5 feet off the ground to avoid being at eye level for children, right? Now, the state's articulated objective in this case for passing this particular regulation was to decrease tobacco consumption by children. And the court noted that this was a substantial, right? This was an important objective. However, the law was deemed unconstitutional because it did not meet the least restrictive means part of the Central Hudson test, which was that fourth prong, right, that we've talked about. First, not all children are shorter than 5 feet tall. And even if they are, they can look up and take notice of their surroundings, right? And so the court noted that the 5 foot placement requirement wasn't the least restrictive means. The court also talked about the smokeless tobacco piece of this regulation. And they noted that if the government is really trying to reduce children from smoking, and the government had not in that particular case shown that children who smoke also chew tobacco. So that was another issue that the court had. But if they really were trying to reduce children from smoking, then this particular approach regarding smokeless tobacco was not the least restrictive means to further the interest, right? And this means that they chose, this restrictive advertising, was still likely to be seen by children, right? And so the court noted that the restriction chosen basically forecloses almost all outdoor advertising. And as a result, it was deemed to be unconstitutional. So that's our take or consideration, if you will, of the category of commercial speech under the topic of speech that is unprotected or less protected under the First Amendment. And so that leads us into our final topic regarding unprotected or less protected speech, and that is torts and the First Amendment, right? Torts and the First Amendment. Now, it's important for you guys to note that the defamation or that the topic of defamation has been tested on the tort section of the Louisiana bar exam in the past. So you should keep that part in mind. Now, it's important to understand that the primary torts that we'll be discussing or that are considered here are defamation and intentional infliction of emotional distress, but others do in fact exist, right? So some tort actions impose liability based on speech. And again, actions like or tort actions like defamation that consist of libel and slander, right? Which is essentially liability for speech that's injurious to a person's reputation. There are also, in some jurisdictions, words, or it's considered that words could be the basis of challenges, right? That regard intentional infliction of emotional distress. The First Amendment puts limits on some of these actions that impact speech, right? And we'll talk a little bit about those types of cases. The concern surrounding allowing tort suits for injurious words or speech may have a chilling effect in quiet speech, right? That is the ultimate concern, because if you have these regulations that allow civil suits for words or speech that may injure a person's reputation or cause a person to feel a certain way, then it evokes this fear, right, of having to pay civil damages in a civil suit type of context, right? So the court balances these First Amendment concerns against the rights of the plaintiffs when evaluating who can sue successfully and under what circumstances. So how then does the court balance these concerns, right? And essentially, there are four types of scenarios that exists where torts and First Amendment speech concerns intersect. And so the first scenario is where a plaintiff is a public official or is running for public office, right? A second scenario is where the plaintiff is a public figure, i.e., maybe a celebrity or a person who is famous, right? Not a public official, but a public figure. A third scenario is where the plaintiff is a private figure, and the matter that is being sued upon is a matter of public concern. And then finally, the final scenario is where the plaintiff is a private figure and the matter is one that is not of public concern, i.e., the matter is one that is of a private nature or a private concern, right? And so these are the scenarios where torts and the First Amendment kind of intersect. And so we'll talk a little bit about these issues very, very briefly. So the first scenario where you have the plaintiff may be a public official or an official running for public office, right? If the plaintiff is a public official or running for public office, recovery in these types of scenarios is only allowed for defamation by proving with clear and convincing evidence the falsity of the statements that have been made about the plaintiff and actual malice, meaning that the defendant knew that the statement was false or acted with reckless disregard for the truth. And you see this become, or you see this be laid out as the standard in the 1964 case of the New York Times versus Sullivan. And in that particular case, Sullivan was an elected official in the city of Montgomery, Alabama. He brought a libel suit against 4 Black ministers and the New York Times based on a full-page ad that had been published in the paper that was describing various acts that were going on in Montgomery and the state of Alabama that hampered the progress of civil rights in the state, right? As a result of the advertisement, police responded with violence to peaceful protests by demonstrators, one of which included Dr. Martin Luther King Jr. So some of these statements about the events were not exactly true. And so the trial court took up the issue and found in favor of Sullivan and awarded Sullivan $500,000 in damages, right? And the Alabama Supreme Court affirmed this award. So the matter was taken up by the United States Supreme Court. And the court held that the rule of law applied by the Alabama courts was constitutionally deficient for failure to provide safeguards for freedom of speech that and the press that were required under both the 14th and the First Amendment, right? And so important in the Sullivan case is that the court laid out a test in cases involving public officials on matters related to public office. And so the test essentially conveyed that first, in these particular instances, the plaintiff had to be a public official or be an individual running for public office. Second, the court noted that the plaintiff had the burden of proving by clear and convincing evidence the falsity of the statement, right, that had been made, meaning that that statement was false, and that it was made with actual malice, meaning that the defendant knew the statements were false or acted with reckless disregard for the truth. And in this case, the court noted that the statements or that there had not been a showing that the statements had been made with actual malice. So let's unpack a couple of these portions, if you will, of this particular test, right? Naturally, the court's opinion in New York Times or Sullivan or however you would distinguish it raises a couple of questions. First, what is a public official, right? The Supreme Court, interestingly, has never held that all government employees are to be considered public officials under Sullivan. But the court has never formulated a precise test to determine which public employees are in fact public or should be considered public officials. The Supreme Court articulated at one point that public officials for the purposes of Sullivan are those with a substantial responsibility. And the author, Chemerinsky, noted that the court made this holding in the Rosenblatt versus Baer case in 1966. Yet, in reality, over time, lower courts have found it virtually impossible to distinguish among government employees. Virtually all government employees are treated as public officials in lower court cases. Thus, there's really no clear definition, right, that exists as to who is a public official for the purposes of the Sullivan test. And so this is another one of those instances, right, where the court just kind of leaves us hanging. We can certainly surmise that we're talking about government employees, but there's this consideration of, well, how much responsibility, right, does the government employee have or should have in order to justify them to be considered a public official, right? You know that you could have lower level types of public employees, whether it's the folks that are out on the road patching potholes, right? Should they be considered public officials just because they're public employees? Certainly, their jobs don't require them to run for office, right? And it's likely that they don't have what the court considered in Rosenblatt substantial responsibility, which is why you kind of have this seemingly difficult time in terms of defining what a public official is. Additionally, note that the burden of proof here is one of clear and convincing evidence, right? And this is a much higher standard than the normal standard in a civil case context of a preponderance of the evidence, right? You know from your torts classes that a preponderance of the evidence is kind of like a 51-49 type of burden of proof, whereas a clear and convincing burden of proof is more than 75% certainty, right? And so this standard of proof, if you will, is much higher in a public official case, right? Additionally, in these types of cases, the plaintiff must prove the falsity of the statements. And so this presents a difficult issue in drawing a distinction between expression of opinion and false statements of fact, right? Since really separating opinion from fact is inherently difficult, right? Therefore, for this particular point, the focus is not on whether a statement is opinion, but whether it contains directly or by clear implication, factual statements. So keep that part in mind as it relates to the falsity of the statement element. And then finally, as we've talked about, the proof must there must be proof rather of actual malice, meaning that the defendant knew that the statement was false or acted with a reckless disregard of the truth. The court has explained that this requires proof that the statements were made with the high degree of awareness of their probable falsity, right? And so there is how we kind of unpack this test that the court articulated in Sullivan regarding cases involving public officials on matters related to public office in a defamation sort of context, right? So, what about instances of public figures, right? And so the court has held that the same rules apply in defamation suits brought by public figures as applied under Sullivan, right? And so public figures, again, are people who are considered to be in positions of prominence, right, in their community, those who have thrust themselves into the limelight and thus have, in a way, voluntarily exposed themselves to increased risk of injury from defamation or defamatory falsehoods, right? And they are also subject, the court has articulated, to the same standard used for public officials, right? And the court initially articulated this position in the case of Gertz versus Welch in 1964. I'm sorry, 1974. This case dealt with a private citizen on a matter of public concern. And in Gertz, the Supreme Court made clear that there is a key distinction between public figures and private figures, and differing rules exist for each. Now, Gertz involved a case of a prominent Chicago lawyer who represented a family of an individual who had been shot by a police officer. A libelous article was published about Gertz that contained numerous false statements, including saying that he had a criminal record and that he was a Leninist or a communist frontier, right? Making accusations that he was essentially a communist. And so the question that the court was presented with was whether the standard for public figures or officials that had been set out in the Sullivan case applied in this particular instance. And the court held that the Sullivan standard did not apply because Gertz did not meet the definition of public official nor of public figure. Gertz, or the Gertz court, defined what is a public figure, right? And it concluded that Gertz was not a public figure. Rather, Gertz was considered, in this case, a private citizen, right? He wasn't someone who had assumed a role of special prominence in the affairs of society. The court noted that some occupied positions of such persuasive power and influence that they are deemed public figures for all purposes. As we talked about earlier, the court noted that these sorts of individuals have thrust themselves into the forefront of particular public controversies in order to influence the resolution of the issues involved. And so the court also considered that public persons have better access to self-help measures of defending their names and reputations than do private individuals, right? And so you see in Gertz that there's this articulation of what is considered a public figure, but also, interestingly enough, Gertz articulated the standard for defamation recovery by private figures. And Gertz articulated that private figures, again, are obviously plaintiffs who are not public officials are public figures, right? Gertz also talked a little bit about what a matter of public concern is, right? And it's interesting to note that a matter of public concern has never been defined by the court, but generally it refers to issues in which the public has a legitimate interest. And so of particular note regarding instances where the plaintiff is a private figure entangled with or sued in matters of public or private concern is the case of Dun and Bradstreet versus Green Moss Builders. In Dun and Bradstreet, the Supreme Court said that a distinction must be drawn in cases against private figures between speech that involves matters of public concern and that which does not. And so in the Dun and Bradstreet case, Dun and Bradstreet falsely and inaccurately reported to 5 financial institutions that the Green Moss Company had filed a voluntary petition for bankruptcy. And the report ultimately was later corrected, but the damage had already been done. And as a result, Green Moss sued and was awarded $50,000 in compensatory damages and $300,000 in punitive damages. And so in this particular case, it considered the question of whether this rule, right, that had been articulated in Gertz which allowed liability to be imposed for libel against a private individual on matters of public concern, should be applied when the matter at issue is not of public concern, right? So the matter in this particular case was simply the fact that Green Moss's reputation had been injured by Dun and Bradstreet falsely and inaccurately reporting to 5 different financial institutions that Green Moss had voluntarily filed for bankruptcy, right? The court noted that nothing or speech in matters that are purely private, right, is of little First Amendment concern. And in making this notation, the court held that states do not need to require a plaintiff to show actual malice. That's very important, right? Because it's not an issue of public concern, right? They don't, the state doesn't have to be able to, or doesn't have to be required rather to prove or show actual malice in order for a plaintiff to recover compensatory and punitive damages in defamation cases on matters of purely private concern. And so keep that that particular fact in mind and underscore that issue. Why is it important, right? Because what Gertz had essentially drawn out and Dun and Bradstreet essentially underscored was the fact that the state can create liability rules, right? So long as it's not a strict liability and the recovery is for actual injury. Another way of saying this is that state law can create liability if there is negligence, right? And because of this allowance, negligence is a much easier standard to meet than actual malice, right? For negligence, it can simply be shown that the defendant did not check as much as he should have, right? But for actual malice, right, it must be shown that the defendant had a knowledge of falsity, right? And so in this particular instance, or matters of private concern, the court did not institute this requirement, right? And so remember when we embarked on the topic of torts in the First Amendment, we talked about the fact that there are a lot of torts that are implicated under the First Amendment, but we were only going to focus on 2. So we really focus now on defamation in discussing the Sullivan case and the Dun and Bradstreet case and the Gertz cases. So I want to, as we wrap up this topic, navigate now into the second tort, and that's the tort of intentional infliction of emotional distress. And the key case under intentional infliction of emotional distress is Hustler Magazine versus Falwell. Hustler Magazine, you may or may not know, is an adult type of magazine, the equivalent of a Playboy magazine, if you will, that ran a parody of a Scotch ad that showed an evangelist by the name of Jerry Falwell having his first sexual experience in an outhouse with his mother, right? So pretty outrageous ad, right? The magazine noted that it was parody, right? They were essentially making fun of Mr. Falwell. Nevertheless, Falwell sued for defamation and for intentional infliction of emotional distress. The Court of Appeal in that case ruled against Falwell on the defamation claim because he was a public figure, right? Keeping in mind what the types of approaches that the court has looked or considered when evaluating a defamation claim against a public figure. But the Court of Appeals allowed the claim for intentional infliction of emotional distress. However, on that issue, when the Supreme Court took up the issue, they reversed. The Supreme Court indicated a concern with protecting defamation rules in a justification of how it arrived at its opinion, noting if there could be liability for intentional infliction of emotional distress, then any defamation suit could be repackaged for that particular tort. The court also perceived the need to protect satire or parody. Now, Falwell argued that outrageousness should be the line. However, the court refused to set this as a standard and chose to dismiss the intentional infliction of emotional distress claims in Falwell, right? Another important case, and a more recent case than the 1988 case of Falwell, is the 2011 case of Snyder versus Phelps. In Snyder, this case considers a church essentially protesting on some pretty offensive grounds, if you will. So for over 20 years, the congregation of the Westboro Baptist Church picketed military funerals in order to communicate its belief that God hated the United States because the country tolerated homosexuality in the military. And so church members would go to military funerals and use them as occasions for expressing their vile message of anti-gay and anti-lesbianism, right? In this particular case, the father of a soldier who died in Iraq successfully sued the church for intentional infliction of emotional distress when they showed up to protest at his son's funeral. In undertaking the question, the court, in an 8-1 opinion, ruled that liability under intentional infliction of emotional distress violated the First Amendment and determined that the church's speech was, in fact, on a matter of public concern. And the court ultimately concluded that the government cannot create liability or punish speech because it is offensive, even if that speech is deeply offensive, right? So that wraps up our discussion on the topics of commercial speech and torts and the First Amendment. So make sure that you note the important cases that we talked about, note the important tests under these particular topics. You got the Central Hudson test, you got the Sullivan test. Make sure you commit those to your notes and to memory. So if you're presented with those issues, then that you have the ability to articulate the appropriate test. I appreciate your attention and your time, and we will see you on the next video.